আপনাদের সকলকে আবারো আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি আজাম কো সলিসিটার্স এর প্রিন্সিপাল সলিসিটর শাফিউল আজম এবং আমার সাথে আছেন ক্রিমিনাল লয়ার স্পেশালিস্ট ব্যারিস্টার আমার কলিগ ব্যারিস্টার টারা ম্যাকার্টি। এই সেগমেন্টে আমি বলবো ফার্লো ফ্রডের উপরে। কখন ফ্রডটা হয়, যে ফার্লোর জন্য অ্যারেস্ট করা হয়েছে একজনকে 495,000 পাউন্ড ফ্রড করার জন্য অ্যারেস্ট করা হয়েছে এবং অনেকগুলো কমপ্লেইন্ট এইচএমআরসির কাছে আসছে, মানে শতাধিক, অনেকগুলো 795। আমার মনে হয় এইটার ফিগারটা দেওয়া হয়েছে 13th May, এর মধ্যে তো এটা আরো অনেক বাড়ছে। সুতরাং very large amount of complaint has come. What kind of fraud is Farlow fraud? কিরকম, কিভাবে Farlow fraudটা হয় সংক্ষেপে আমি বলবো, then I will pass to my colleague barrister Tara McCarthy. The fraud falls into two main categories: asking a furloughed employee to return to work as a volunteer without pay. যে তোমরা আসো কাজ করো, তাকে বলা হয়েছে যে ভলান্টারি বেসিসে কাজ করো, পয়সা দেব না। ওকে, বাট দেয়ার হ্যাজ বিন সাম চেঞ্জেস মেড বাই দ্য এইচএমআরসি রিসেন্টলি, কিছু চেঞ্জ তারা আনছে। ফলোয়িং অ্যান এমপ্লয়ি উইথ অর উইদাউট দ্য এমপ্লয়িজ নলেজ, যে এমপ্লয়িকে ফার্লো করা হচ্ছে সে জানে না যে তাকে ফার্লো করা হয়েছে, তার নলেজের মধ্যে ছিল না, সে জানতো না। And they continue to work as normal, এবং সে কাজ করতেছিল যে কন্টিনিউয়াসলি সে কাজ করে যাচ্ছিল, সে জানে না যে তার নামে ফার্লো স্কিমের মধ্যে দেওয়া হয়েছে এবং এমপ্লয়ার পয়সা চার্জ করতেছে এইচএমআরসি কে। There will also be examples of the fraud এর আরো এক্সাম্পল হইতে পারে following staff and not paying them what they are owed under the scheme। যেই পয়সাটা এইচএমআরসির কাছ থেকে নেওয়া হয়েছে, এমপ্লয়ার যেটা ক্লেম করেছে তাদের নাম দিয়ে ফার্লো করা হয়েছে এবং সেই পয়সাটা তাদেরকে দেওয়া হচ্ছে না, সুতরাং দেওয়া হয় নাই, এটাও ফ্রড। Employers making backdated claims that include periods in which the employee was working, তারা এমন ব্যাকডেটেড ক্লেমগুলো করেছে ফার্লো স্কিমের আওতায়, অ্যাপ্লিকেশনগুলো এইচএমআরসির কাছে করেছে যেগুলো তখন সে এমপ্লয়ি, সে কাজ করতেছিল, ওই সময়ে তার পুরা দমে সে কাজ করে যাচ্ছিল, কিন্তু ফার্লো স্কিমের আন্ডারে এইটা এইচএমআরসির কাছ থেকে পয়সা ক্লেম করা হচ্ছিল। Employers pretending to hire a staff shortly prior to the qualifying period to take advantage of the payments, ঠিক কোয়ালিফাইং যে পিরিয়ড যেটা দিয়েছে ওই নির্দিষ্ট তারিখের আগে মানে অনেকগুলো স্টাফকে রিক্রুট করা দেখানো হয়েছে, তা মানে রিক্রুট করা হয়েছে এবং শর্টলি প্রায়র টু দ্য কোয়ালিফাইং পিরিয়ড, জাস্ট মানে ওই তারিখের আগে এবং ওই স্কিমের অ্যাডভান্টেজ নেওয়ার জন্য, তাদের নামে যেন ফার্লো স্কিমের আওতায় যেন ক্লেম করতে পারে, স্কিম শুরু হওয়ার ঠিক আগে তাদেরকে স্টাফ হিসাবে নেওয়া হয়েছে, ওইভাবে দেখানো হচ্ছে এবং এই স্কিমের অ্যাডভান্টেজ নেওয়ার জন্য যেন পয়সা ক্লেম করতে পারে এইচএমআরসির কাছ থেকে। Not paying the full amount received from HMRC to the employee, যে অ্যামাউন্টটা ক্লেম করা হয়েছে, কারণ এইচএমআরসি বলছে কি 80% or 2,500 পাউন্ড ম্যাক্সিমাম। ওকে, ওইটা আপ টু যেটা লোয়ার ফিগার ওইটা এইচএমআরসি দিবে, আইদার 80% অথবা 2,500 পাউন্ড। কিন্তু যেই পয়সাটা এইচএমআরসির কাছ থেকে ক্লেম করতেছিল এমপ্লয়ার, সেটা তাদেরকে দেওয়া হচ্ছিল না। সুতরাং এগুলো হলো কয়েকটা এক্সাম্পল ফ্রডের জন্য, যেটা আপনার অনেকগুলো কমপ্লেইন এইচএমআরসি কাছে গেছে, তারা এগুলো এখন ইনভেস্টিগেশন শুরু করেছে, অলরেডি অ্যারেস্টও হয়েছে। এবং কারণ করোনা ভাইরাস জব রিটেনশন স্কিম গাইডেন্স এক্সপ্লেইনস ভেরি ক্লিয়ারলি দ্যাট এইচএমআরসি উইল বি চেকিং ক্লেইমস। দ্য করোনা ভাইরাস জব রিটেনশন স্কিমের যে গাইডেন্স যেটা আছে, ওইখানে ভেরি ক্লিয়ারলি এক্সপ্লেইন করা আছে যে এইচএমআরসি উইল বি চেকিং ক্লেইমস, এভরি সিঙ্গেল ক্লেইম তাদের কাছে পাঠানো হচ্ছে, তারা এগুলো চেক করবে। মানে ক্লেমগুলো, এগুলো কি জেনুইনলি করা হয়েছে না ফ্রডুলেন্টলি করা হয়েছে, এবং ঠিক মতো পয়সাগুলো এমপ্লয়িরা পাচ্ছে কিনা। এবং তারা অনলাইন পোর্টালও এখন করেছে যে এমপ্লয়িরা যদি সাসপেক্ট করে এমপ্লয়ার ফ্রড করতেছে, তাদেরকে পয়সা দিচ্ছে না, এটা রিপোর্ট করার জন্য এইচএমআরসি আপনার অ্যানাউন্স করেছে। আমি ফার্লো ফ্রডের ব্যাপারে এটার উপর আরও আপডেটগুলো নেক্সট প্রোগ্রামের মধ্যে আমি বলবো, যে নতুন কেস যেগুলো হচ্ছে সেগুলোর উপরে। বাট I will now pass to my colleague Barrister Tara McCarthy to talk, Tara, on more on sexual offences, maybe child abuse. What is child abuse? If you can just go on that one first, please.
Of course. So child abuse is an allegation by a child, and a child is defined as a person under the age of 18 against either another child or an adult. In England and Wales, there are 3 categories of children. There are those under the age of 13, there are those under the age of 16, and there are those under the age of 18. And the 3 different categories reflect what the courts see as 3 different areas that need different levels of protection. So offences involving a child under the age of 13 are the most serious. Even if you believe that the child under the age of 13 is in fact older, it doesn't make any difference, because if you engage in sexual activity with that child, irrespective of what you believed, how old you believe them to be, you are committing a very serious offence. And it's important to ensure that if you are going to do anything with someone who is younger, that you find out how old they are. And that applies if you are 20, if you are 30, or if you yourself are 16, 15, 16. You cannot engage in activity with a child under the age of 13. And our offences in England and Wales are designed to protect that group particularly, and there are higher penalties for offences involving the under 13s, higher prison sentences, and also longer term effects in the sense of restrictions on you in the future, and also the type of prison sentences you receive and how long you will stay in prison. So it's very important, if an allegation is made against you involving a 13-year-old, what can you expect? Well, the first thing is that 13-year-old is very likely to give their evidence to the police via a video interview. And that is because it's considered the best way of getting their account. When they first speak to the police, they will very shortly after that be interviewed by specially trained police officers who may have with them a person who is called an intermediary, so someone who can help ensure that the young person understands the questions and that they can give their account in the best possible way. When it comes to the cross-examination of these witnesses, more and more courts are implementing a procedure which means that these witnesses are cross-examined ahead of any trial. So what will often happen, and you need to be prepared for this if you face this allegation, that you understand it's very different, because what is likely to happen is that your barrister and solicitor will need to prepare the questions for this child or young person in advance of the main trial where the jury watch, because this will be pre-recorded. And so it's important that you've cooperated with your solicitors, that you have given them your instructions, so told them your account, and that is done in sufficient advance so that the barrister and the solicitor can prepare to cross-examine them. Now, when witnesses who are children or vulnerable people are cross-examined, there are rules and restrictions about how you can ask questions. And as has already been said, it's really important that we have a sensible approach, that witnesses are asked questions in a sensitive way, bearing in mind their age and their understanding, and that will be very much policed by the court. So pre-recorded cross-examination is quite a new thing in criminal justice in England and Wales. But what it does is to try and ensure that young people who make allegations of sexual assault are asked questions pretty close to when things have happened, and also that there is an opportunity for that to be heard as soon as possible. And there will be restrictions on what questions can be asked and also how those questions are asked, which is very different from a normal witness who you can robustly put a case to. However, following those restrictions isn't necessarily a negative thing, because quite often it ensures that juries A, understand what the evidence is, and B, it ensures that defendants can robustly fight their cases in an appropriate way that juries don't find offensive. One of the hardest things when an allegation of child abuse is made is this desire for people to fight and to be aggressive. And it doesn't work, and it can sound dreadful to a jury. And these measures which have been brought in actually help defendants put their cases in a way that makes it a lot less aggressive in front of a jury. And then it's down to a defendant really to explain his or her position as to what's gone on and to counter what the child has said, but done in a way that's far more sensible and a staged approach to the trial. So in terms of allegations of child abuse, again, it's a very broad area, very broad topic. There are all the offences involving deliberate sexual activity with a child. As I've already said, that's split into activity for those under 13, those under 16, and then those under 18. In terms of the offences, there are the offences of penetrating a young person's vagina or anus or mouth, which is Section 5. There are offences under Section 6 about a person intentionally penetrating with other objects. Section 7 is in relation to touching, so sexual assault. Section 8 is about causing or inciting, is the word we would use, a child to engage in sexual activity. And all of these offences, as I've already said, it doesn't matter if you thought that child was under the age of or over the age of 13. It doesn't matter. It's what actually they are that counts. And then these offences can be are regarded as serious depending upon the circumstances. And so as a consequence, you have a staged approach. The more serious matters will always be tried in the Crown Court. The less serious matters can be tried in the Magistrates Court, although you do need to be aware, and it is an important factor, as has already been said, that when somebody is tried in the Magistrates Court, they could always end up being sentenced in the Crown Court. And so many people may think, well, is there a point of actually being tried in the Magistrates Court if I'm going to then end up and be sentenced in the Crown Court? But that is a matter for you to decide. It's a decision you take following the advice about your specific case and with your solicitor and your barrister. And so going back then to the types of offences you have, so the 2003 protects children from having sex at too early an age. It also looks at the maturity levels between the offender and the complainant, because sometimes people can have different ages, but they may have different levels of maturity. And so certainly with defendants who are young themselves, the level of maturity is something that will be very much considered when looking at whether what's being charged, and if a conviction results, the type of sentence which is imposed. And also, sometimes individuals who are very close in age, the prosecution may make a decision that they don't wish to prosecute because they don't feel it's appropriate. But equally, if there is a level of exploitation or coercion or threat or grooming or manipulation, it may well be very much in the public interest to prosecute. The offences then are staged. So you have then the offences affecting those between the ages of 14 and 16. And it is still unlawful to engage in sexual activity with those under 16. And there is still an issue that they can't consent. However, with those series of offences, there is scope for someone to say, well, I thought they were over 16. And that can, in certain circumstances, be a defence. Again, these offences are very similar in terms of what they criminalise and what you can and can't do. And it's always looking at what's happened, what's said to be the circumstances behind it, as to how serious or not it's taken by the courts. And in terms of an offender, if an offender is under the age of 18, so 17, say, they can be treated very differently if they are committing these offences than someone who is over the age of 18. That threshold is very, very important with these types of offences. And so it's quite important to consider the circumstances of what it is that is being said to have occurred. Now, in addition to these offences, there are lots of other offences which fall under the category of child abuse. These, for example, such as arranging and facilitating a child sex offence, trying to meet somebody with a view to engaging in sexual activity when that person is a child, bringing someone or arranging for someone to come from abroad to engage in sexual offences. And so these are the type of offences.
We are running out of time today, Tara. So I know you wanted to talk more about the child abuse.
Sorry.
It's very important and very large topic, but we don't have the sufficient time now. We are almost finished now. So we will be talking on the historical sexual abuse case in the next program. I know you prepared for the historical sexual abuse case. This is very, very important, been happening now a lot. We will come back to that one. Darshok, next program, Tara McCarthy barrister will come again and will talk on the historical sexual abuse cases. আজ আমাদের সময় প্রায় শেষ হয়ে গেছে। আজকের প্রোগ্রামটি আবার পুনঃপ্রচার করা হবে, অর্থাৎ রিপিট দেখানো হবে নেক্সট টুইসডে দুপুর 12:30 থেকে 2টা। তাছাড়া এনটিভি ইউরোপের ফেসবুক এবং ইউটিউব থাকুন, সুস্থ থাকুন এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।